part one of the overlays, and we are in session number 2. We've just heard from the Section 42A officer on sites of Samari, both Hamish Wesney and Morgan Billowfield. Thank you both. We're now going to move on to the topic of historic heritage and Becca Adams. Before we do, Hamish, on the first topic, and under the topic of risk of acting and not acting in terms of unknown sites or known sites that are not protected, could the right of reply address the extent to which the archaeological authority process might alleviate some of that risk? In the sense that whilst it's not a district plan process for pre-1900 activity, an archaeological authority would be required under the Heritage New Zealand Act.
Okay, thank you.
Thank you. Okay. Right. Morning, Becca.
Good morning.
Morning. Same sort of approach that we've undertaken, but what I can say is that we are particularly interested in few issues that deal with the mechanics of the plan, particularly how the issue of curtilage works. An undefined term in the plan. Would like to know a little bit more about that. Yeah, we can direct you. So I guess the issue of precincts and the issue of non-contributing and contributing buildings, and controls on the demolition of non-scheduled buildings. So these are issues that have been raised by Heritage New Zealand. So you take us through your introduction, and then we can move to your appendix. We can go through some of those issues here together.
Okay. Yep. No, that sounds good. I just wonder if I invite David Coonahan to.
How rude of me. Sorry, Mr. Coonan.
Very rude.
Welcome.
Thank you.
And yes, we'll come to Mr. Coonan at the appropriate time.
All right. So I take the first 2 paragraphs as read.
Yep.
And start at paragraph 3.
Yes, that's
So Section 6 of the RMA identifies the protection of historic heritage from inappropriate division, use and development as a matter of national importance. The Historic Heritage chapter is to implement Section 6 of the RMA by identifying and protecting Wairarapa's finite heritage, to maintain linkages to the past and insights into the development of the Wairarapa we know today. Wairarapa has a rich cultural and spiritual heritage found in buildings, features and areas of buildings or features that collectively have significant heritage value, as well as other sites and features covered in separate topics of this hearing. The District Plan Review has updated the heritage schedules and design guides to reflect the current context, as well as introduced new definitions and rules to better enable maintenance, repair, strengthening, and accessibility upgrades to protect and maintain heritage values. The proposed district plan strikes a balance between protecting heritage whilst recognising and providing for appropriate development of properties and private ownership. The review and update of the heritage schedules is based on the criteria of identifying sites and buildings and items set out in the Wellington Regional Policy Statement. And Appendix 1 provides a summary of the activity status of different land use activities in relation to heritage buildings, items and precincts.
Before we go to Appendix 1, you have a copy of Policy 21 from the Wellington Regional Policy Statement?
I do.
You have multiple copies of it?
Oh, I have one. It may have a coffee stain on it also.
I'll go and find a copy.
Oh.
I think we will need that for later in the hearing also.
Yeah.
While we're doing that, Mr. Weston, one of the questions I omitted to ask yourself and Morgan relation to SESMs is the national and regional direction for those. So we touched on 6 Part 2 matters in her summary, but there's no explicit reference in her summary to what the policy framework is in the RPS. Presumably there's a similar policy to policy 21 with lots of interest to Maori.
Do you want us to cover that in the reply?
I would, thank you. Hey, shall we go to Appendix 1?
Yep. And
I've also got a copy of the Historic Heritage chapter in front of us marked up. This is the section 42A version. I don't think you printed. This was an Appendix 4. I don't know if you printed.
No, I don't think I did actually attach it.
Do you want to just take us through the mechanics, how schedule, what the difference between the two schedules, the sites and precincts, what the policy flavour is for each of those and what the rule framework is?
Yeah, so
And the relationship with the Heritage Design Guide.
yeah, so there's Schedule 1, which is the schedule of heritage buildings and items, and Schedule 2 is the schedule of heritage precincts. And then, yes, I think we touched on them during the residential zone hearing and the commercial zone hearing. There's design guides for those zones, and within them, they outline kind of the characteristics of those heritage precincts and any new buildings and development in those zones.
Okay, so the design guides just relate to the precincts, they don't relate to individual living.
No, they don't, just the precincts, yes.
What about the metrics? We've heard about the metrics for the SASM sites. How do the metrics compare for heritage sites, ODP versus proposed plan?
Yeah, so the operative district plan is quite interesting in terms of heritage. I think there's one permitted rule, and that's in South Wairarapa, and that's minor repairs and maintenance within a heritage precinct. And there's no definition for repair and maintenance within the ODP. So that's something we've captured in this review process. And then all other activities, be that subdivision, more than minor repairs, are captured as discretionary activities. And that's in relation to both items and activity within the precinct.
I was thinking more of the number of sites and the number of precincts.
Oh, sorry.
Between the ODP and the EDP.
The precincts have stayed the same, though you'll note in my report that Atakitaki Akupe has been removed and is now within the SASM's Schedule 4.
That's recommended.
More appropriately placed in the SASM's, yeah.
And in terms of the individual heritage items?
I believe there was 14 new items added.
Across the 3 districts.
Correct.
Okay.
I believe actually most of them, I think there was 2 in Masterton. I can confirm this in my right reply. 2 in Masterton and the rest were in South Wairarapa. There were additions in Carterton.
And did I read somewhere that there in total there's over 400 things?
Over 400. I'd have to go through and count them again based off my recommendations to remove or add.
Yeah. So just moving to the Appendix 1 with the rule framework. Can you just take us through the policy framework first, please, as a precursor to looking at the rules?
So there's 2 objectives, and that's recognising historic heritage, protecting historic heritage. And those really capture in Section 6 of the RMA.
What's the what's your understanding of the difference between recognising and protecting?
I think recognising is kind of the identification, I guess you could say. And I guess that's through the listings.
Yes,
And then the protection is the rules
yes.
and how to develop and protect appropriately.
One without the other?
Well, I guess in terms of the RMA, it does say, I believe the wording is both protect and recognise.
Put it this way, let's ask that question.
Well-
Like, could you protect an item if you haven't identified it? The district plan. Conversely, you could presumably identify an item but not protect it.
Yes, you could, but I don't believe
Whether that's sound practice is another issue.
exactly. Yeah.
So it seems that prerequisite to protection is identification.
Yes. Yeah. Well said.
Or are there, take this a little bit further. Are there levels of protection that you can add to things without impacting upon property rights to the extent that some of the rules currently would do? So we identify something and then instead of having rules that make a material financial difference to the value of that property for the owner, are there ways in which we can formulate protections that still enable people to retain the value in there without imposing things that would have a very adverse effect on property values, for example?
I believe so. I feel like that's where we have those permitted activity.
I asked the question because obviously you're going to hear a submission this afternoon,
Yeah.
which has a material quantifiable impact by what we're proposing in these rules. So my question is how can we mitigate that within the rules to enable people to still have value in their property unaffected by protecting its heritage?
Take that further. I mean, I think what the councillor is indicating is there different degrees of protection, and is there also protection that can occur outside of the district plan without the plan rules? How certain that?
I think there are different levels of protection. And I think that's where through historic heritage assessments, they've identified what characteristics of sites, if they're scheduled sites, what should be protected. I recognise it's a fine balance between cost to landowners and a cost to, I guess, a loss of heritage.
Let's explore that further through the policy framework. So there's some 12 policies. First two policies seem to mirror the first two objectives in terms of identification and protection.
Yes.
Then the policies from P3 through to P12 are the basis for the different types of controls that we see in the rule framework. So you're looking at P4, some additions and alterations, partial demolition is provided for. P5, earthquake strengthening and fire protection is structures and curtilage, word comes up again, of scheduled hearings is provided for. Building instructors and scheduled heritage precincts are provided for. The relocation, and so we change the language then. P3 to P7, and then P8 we jump to avoiding the relocation or any scheduled building item. And then P9 avoiding demolition. So the P8 and P9 as a higher level of protection, isn't it? Then what's at page 3, 4, 5, 6, and 7? Is that too much of a simplification?
I think that's
Okay. And then P10 is is similar to the policy that councillor Jepson talked about for the SADMs about public awareness and getting public involved and landowners involved. And that presumably that's something that can happen outside of the district plan. Okay. And you've you've suggested a new policy, PXX.
Yeah.
So relatively permissive, enabling type framework in P3 through to P7, and then a more controlled framework in P8 and P9. How does that translate into the rules?
Yeah, so I guess Appendix 1 shows it kind of clearly with the colours.
Okay, yes.
Um,
Page 9.
yeah. So yeah, really those policies are there as guidance for resource consent decisions. And you'll see, I guess, as you said, those later policies are the more controlled ones, and they relate to those activities, particularly that are restricted, discretionary or discretionary.
So that's the orange and the
They kind of
dark orange, like
yeah.
yes.
So essentially, I guess the rules, the permitted rules relate to that strengthening, alterations, small additions, particularly where they're inside the building. Anything outside triggers a controlled or restricted discretionary activity, so that we can assess the effects of that.
Hey, you've jumped into an area that I was going to ask.
Oh.
Go to that now. I presume this depends on the nature of the listing, but is what is being protected the exterior of the building or the interior of the building, or both, or does it depend on the specific listing?
I think it depends on the specific listing, where we don't have too many where the interior has been.
How many?
I can get back to you on that number. Yeah.
I mean, we're talking.
I'd say less than 10. Yes. So it's really the external facades that we're protecting.
I could just
Yes, Mr. Kernan.
site and place are words that are used in the Act and not necessarily building.
No.
So I see the dilemma, and it is a dilemma as to whether an interior is named and
Yes.
how much of the interior. It becomes very convoluted, and I think.
And you would agree, presumably, that if an interior is listed, it would have required an extensive review of the interior.
It would require a conservation plan.
Yes.
Yes.
Still dealing with items at this stage. Thank you, Mr. This issue of curtilage, it's used in the rules, but it's not defined, is it?
It is defined.
It is defined?
Yes. Would you like me to read out
I would.
the definition? So it means the land, including land covered by water, surrounding a listed heritage building or item that is essential for retaining and interpreting its significance. It can apply to either land integral to the heritage item or a precinct that includes buildings, relics, areas, and their settings. And that is also, that definition is in the operative district plan as well.
So that definition applies to both precincts and items.
Yes, but I believe it is only referred to with items.
Yes. What are the rules that deal with curtilage?
Rule 2 and Rule 10, I believe. But rule 2 is a permitted activity. So that's the demolition of non-scheduled building or structure within a heritage curtilage of a heritage building or item listed in Schedule 1.
Hang on, just hold on, well, maybe. Toggling between your appendix 1 and the actual rules themselves. R2, demolition of a non-scheduled building structure within a heritage curtilage of a heritage building or item listed. Okay, so we've got a rectangular site, and we have a building on the frontage. Basically, say it goes to the entire frontage with minimal setbacks from the front yard and the two side yards, and there's a large area of grassed area out the back. Is that the curtilage to that building?
I would personally say so. If this was particular, it's a case by case
Yes.
and site specific, but that sounds to me a bit like a residential property.
Yes.
Yes, heritage curtilage I accept is very.
Is it the entirety of that backyard? I'll ask Mr. Kernan and the same question in a minute. In your view?
In my view, no. I think if this was a residential section, I was simply looking at it like that, I would be saying that it's probably that streetscape value more so.
Just read that definition again so we can get a feel for
Yeah.
that.
So it means the land, including land covered by water, surrounding a listed scheduled building or item that is essential for retaining and interpreting its significance. It can apply to either land integral to the heritage item or a precinct that includes buildings, relics, areas and their settings.
So we know potentially it's the entirety of the land, but we know that to qualify, it needs to be essential to.
Essential to retaining and interpreting its significance.
Okay, so that might introduce the concept of proximity of the land to the building.
Yes.
Mr. Kernan, would you disagree with that? What's your view on the curtilage?
My first question is, what's the, excuse me, the curtilage of St. Gerard's Monastery in Wellington?
Yeah.
Whole harbour. And also curtilage, to my view, is a three-dimensional thing. I think Ms. Adams mentioned the Fortuna Chapel and curtilage there. Interesting that was a building that had the interior protected and the curtilage protected. The curtilage was intended to be equivalent to a marae space because there was this idea of procession into the chapel.
Yes.
And so the curtilage was defined as the grass space in front of it. So maybe curtilage isn't the right word because, as Ms. Adams has mentioned, a garden or some neighbouring buildings may affect the heritage aspects of a or heritage building. How far you go,
Yep.
It seems to me one of those things that you take on an ad hoc basis.
Sure.
And it's a matter of judgment at the time. I'm very wary of being trying to be specific or prescribing.
Yes, and I'm not trying to get that from you. I mean, what I'm trying to ascertain is whether there's enough certainty in the term for a permitted activity to for a person undertaking a permitted activity to know with certainty whether they are affecting the curtilage or not. Similarly, that's rule 2, and for rule 10, same issue, which requires, I think, a discretionary activity.
And that's in relation to the precincts.
And so we're getting into the matters raised by Heritage New Zealand here. And the request there is that the curtilage be mapped for the 400 listings in Schedule 1, putting aside the scale ask. Now that would give certainty as to when Rule 2 was triggered and when Rule 10 is triggered. And so there would be clear interpretation as a result of that. The alternative is not to define those that spatially and rely on the definition. But we've already heard from Bernard that depends circumstances, and one man's curtilage might be different for another person. So and we'll come back to this and we deal with the issue for Heritage New Zealand, but just wanted, it's good to know that it's defined. I didn't appreciate it was defined. Whether the definition is appropriate or helpful is another question.
Interesting to know it was defined in the ODP. What is
It is defined in the ODP, but interestingly, it's not in the rule framework. It's actually just mentioned in chapter 22, the assessment criteria.
okay?
So
That's going to be my question. How is it applied in the rule? And it's not okay. Thank you.
Just in terms of mechanical questions at this stage.
Yeah, so my mechanical question then is within the rules, I suppose, we talk about relocating buildings out of the heritage area. What about relocating buildings from other areas that may have heritage value from those areas and relocating them into our area? What's the rules around that, and how does that then equate to we then slap a heritage listing on it, even though it's not from our district?
Can you take, in answering that question, can you take the Commissioner to Appendix 1?
yes. So yeah, the relocation of buildings, if buildings are coming into the district, I would imagine,
Well, let's have, you need to distinguish between site and a precinct. So a new building,
precinct.
a building coming into a heritage site onto the curtilage of the heritage site, or that's scenario 1. And scenario 2 is a new building coming into a heritage precinct. What's the rule frame?
So a new relocated building within a heritage curtilage of a heritage building at Schedule 1 is a restricted discretionary activity.
Under Rule 5?
Rule 5, yes. And those matters of discretion are listed there. So that's, I guess,
That would go to the effects of that new building on the integrity of the listed building.
correct.
No, that's not quite what, that's not the question I'm asking. I'm sorry.
No, but you asked what the rule framework is. So
Yeah, but how did, so we've got a couple of examples and we've got people submitting on it saying, my building is not from this area. I bought it in and now I've been slapped with a heritage.
That's a different question, Councillor.
But that's what I'm asking. Is there a rule around that when a building of a heritage of value from another district gets bought into our district, then what is the rules around how do we assess this as a heritage issue for our district?
For a building that's listed in the proposed plan, or are you talking about a future scenario?
I'm talking about a future scenario. So I want to go. So if we use an example, the Greytown pub, the one that was transported over the hill. Okay.
Which one?
The White Swan, yes, sorry, White Swan. I should know it occasionally. But that's not a local building, but it's been transported to here and now it has a heritage listing on it.
So you're wondering what the situation would be.
How does that apply?
In the future.
It's not a heritage building for Greytown because it's not from Greytown, but we have now whacked it with a heritage listing of Greytown.
So so if there was a similar building that was to come into the district in the future, what's the process for listing that building?
Well, will that be come around for the next review? I guess there'd be a historic heritage assessment, and under policy 21.
Yes.
So
it would involve a first schedule process.
Yeah.
The public would
Yes.
have an opportunity and landowners would have a chance to submit. So
I sort of wonder, if we haven't got rules around these things, we may well discourage such practices of bringing older buildings in
Yeah.
because there's no certainty about what might happen to that. So they might go to a considerable cost to bring something in. And then all of a sudden the value of that is reduced because it then has a heritage listing on it.
Yes, so the answer to that might be, bear with me and tell me if I'm possibly wrong. If that new building comes into a existing heritage site on the curtilage, it would require consent. If it came into a heritage precinct, it would require consent. Into a site that was neither a heritage site or a heritage precinct, it would be a relocated building.
Yes, it would.
And whether it's in the rural zone or the urban zone, and the relocated building provisions and zone provisions would apply.
Yes.
Wouldn't have any heritage value as such under the district plan unless there's a future plan change to give it.
Exactly. Yes, and if it was coming outside of the district, that would be for the other district council to assess the relocation if it
So if it's coming,
a scheduled building in their district.
Wellington City might have a similar rule about the loss of that building from Wellington. Does that answer?
Well, I'm sort of struggling because we've got a submission that has been made about somebody's house who didn't have a heritage listing where they bought it from. They relocated it to, I think it's Greytown.
Yep.
And now it's got a heritage listing in Greytown.
Yes. That's a different
But
situation.
it's not in the precinct, and
Yeah.
it's literally in the middle of
Yeah. That's a live issue for us.
Yeah, but obviously we need to determine that in itself, but also within the plans for the future, because this is still a future plan. So yeah.
Yes, I just wonder if that's a bit higher up than the district plan, like in terms of the policy statement. Remain.
Well, the site that the council is referring to is subject to a submission of this plan, and we'll be hearing from the submitter this afternoon.
Okay.
Okay, now is there anything about the rule, we'll talk about the policies, anything further about the rules that you'd like to draw our attention to?
I don't believe so, no.
Well, we can probably then go back to your paragraph 8.
A total of 138 submission points and 53 further submission points were received on the topic of historic heritage, including associated Schedules 1 and Schedules 2 and the planning maps. The greatest number of submissions were received on Schedule 1. Submissions were generally supportive of the provisions as notified, with most amendments seeking new listings or deletion of buildings and items, schedules, activities, or to change permitted levels. I have read the respective evidence and hearing statements submitted in relation to the historic heritage topic, being that of Ryan and Nadine Smock and Russell Hooper, Eleanor Cooper and Dean Raymond for Heritage New Zealand, Tom Anderson for Chorus, Connexa, Spark and 40 South, and Andrew Croskery for Marston Trust Sands Trust. I acknowledge the support of Mr. Anderson on behalf of Chorus and others, and Mr. Croskery on behalf of Marston Trust Sands Trust for the recommendations contained in the Section 42A report. I note that Heritage New Zealand was invited to provide further information on the joinery factory Featherston and my recommendation to remove this building from Schedule 1. Ms. Cooper has provided this information and evidence and agrees with my recommendation to remove the building from Schedule 1.
It's no longer contested.
I also wish to acknowledge Mr. Raymond for Heritage New Zealand's observation of my contrary recommendation from Mr. Wesney regarding the listing of Matakitaki Kupe precinct. As noted in the Historic Heritage Section 42A report, Council sought advice from the Council's Multicultural Advisor in relation to the mapping of this precinct and the inclusion of it in both Schedule 2 and Schedule 4. This advice was received following the publication of the Historic Heritage Section 42A report. Advice subsequently received from Council's Multicultural Advisor supported the submission from Heritage New Zealand to remove Matakitaki Kupe from Schedule 2 and retain this feature in Schedule 4, being sites of areas of significance to Māori. This advice and evaluation and recommendation was included in Mr. Wesney's Section 42A report for SASMs in paragraph 248. I concur with this assessment and recommendation to remove the precinct from Schedule 2 and therefore consider this matter raised by Mr Raymond resolved.
So there's definite scope from the New Zealand Heritage submission for that to occur. Were there any other submitters, either in support or opposition to that submission?
I believe
Any original submissions relating to that?
I'd have to confirm. I don't recall just off the top of my head.
Okay. Could you confirm that sooner rather than later?
Yes.
I don't want to for the right of reply. Okay. Right, key issue 1.
Amendments to Schedule 1, former Greytown Hospital. Mr and Ms Smock, owners of former Greytown Hospital, continue to seek that the building be removed from Schedule 1. Mr Hooper has also provided planning evidence to support this request. In their statements, Mr and Ms Smock and Mr Hooper provided further evidence as well as responded to matters raised in my Section 42A report recommending the rejection of the request. Their responses include the failure of process and inconsistency in listings of items, such as notable trees not listed in Schedule 3 where tree nominations were not approved by landowners. The buildings not listed in the operative district plan schedules or with the New Zealand Heritage list. New Zealand Heritage did not make a further submission on this matter, whereas they did for others, suggesting a neutral position. The building has undergone extensive renovations, reducing its heritage value, and significant economic loss and difficulty selling the property. Firstly, I acknowledge the contradictory communication between council officers and the landowner. To explain this, it was agreed early in the review process to list buildings and items in Schedule 1 where landowners agreed. Following council consultation with landowners, the Joint Committee decided to list identified buildings and items in Schedule 1 due to responsibilities under Section 6 of the RMA, despite landowner wishes. This decision was not imposed on the approach taken to Schedule 3 notable trees, as notable trees are not captured under Section 6 of the RMA. It was recognised that property owners and other parties would have this opportunity through submissions and hearings to support or oppose the listing. Mr Hooper has assumed Heritage New Zealand's lack of further submission on this listing as a position of neutrality. I cannot comment on Heritage New Zealand's position. However, I do acknowledge Mr Hooper's observation that 11 of Greytown's 15 listed buildings were entered into the New Zealand Heritage List in 1983. At this time, the former Greytown Hospital was in Crown ownership, and it could have been seen that should Heritage New Zealand have identified the former Greytown Hospital as a building of national importance, it would have been listed at this time. In assessing this matter, I have consulted with South Wairarapa District Council officers who advised the building was likely not listed under the operative plan or the heritage list, as the building was scheduled for demolition due to poor condition. I accept and empathise with the submitters in their work they have done to undertaken to restore the building and any economic loss or difficulty selling. However, these are not matters considered under the RMA process. I agree with Mr Hooper's sentiment that the building may not hold national significance. However, Policy 21 of the Regional Policy Statement directs councils to identify buildings and items of district significance. Mr Kernahan and I agree that the former hospital holds architectural and district significance, and there is sufficient reason to list the building in Schedule 1 when assessed against the Regional Policy Statement criteria. Alternatively, to accept Mr and Ms Smock's request and remove the listing from Schedule 1, there is a risk to public good in the loss of heritage. Although the building was once proposed for demolition and heritage values ultimately lost, the building has now been restored and which preserves the heritage values. The nature of this case is one of a fine balance between cost to landowners and a cost and loss of heritage into the community. Before confirming my position, I would like to hear from Mr and Ms Smock and Mr Hooper, who are scheduled for this afternoon, and I will confirm my position with any additional comment from Mr Kernahan and South Wairarapa District Council officers through my reply statement.
I'll just see what questions we have for you. Alison?
I'll have lots, but I'd probably
Yep.
like to do it at the same time while we've got Snooks and their things to do.
Or there's a chance to ask the officer some questions. You won't get the opportunity later.
Okay, well, I'll start then. If we go down this line and confirm this, given the history of this particular building, what is the risk that people will see this as a planning change after an event and then say, well, I'm not going to do this to my building, I'll demolish it first and then rebuild. So we may well end up actually not protecting the very things we want to protect because we're not being consistent in approach.
You understand the
Entirely.
Okay, so here's a building that was up for demolition.
Yes.
There's no argument that there was a demolition instruction on this building. It was bought by the previous owners who bought it with that demolition order in them. And there was no heritage listing on it whatsoever. It was a derelict building ready for demolition. There has been considerable money reinvested into that building on the basis that it wasn't a heritage building and it was open for demolition. So it was effectively a greenfield site. Now they've done that and invested all that money. We're now going down the line and saying, oh, well done, great, fantastic. Now we're going to put a heritage listing on it. What is to say, if we do that, isn't that going to put a chilling effect on people in the future doing exactly what they've done? Because they'll go, I'm going to invest millions of dollars rebuilding this building, and then you're going to take some value of that by, not you, but the community is going to then take some of that value away by putting a heritage listing on it after the effect. Now, there's considerable comment from the Snooks and the previous owners that they would not have done this had they known this would have been the outcome.
Mm.
So the problem is that we risk the very opposite of what we want to achieve if we do this in retrospect.
Is this a question you think you can answer?
Not on the spot. I think.
Is that within your domain as a planner for us to that question?
Could I,
No, I don't.
Mr. Kernan, just hang on, we'll come to you in a minute.
Do you understand what I'm saying?
I do understand what you're saying. But yeah, I don't feel like it's probably within my scope to respond to that.
Have you got an alternative question then? We'll come to Mr. Kernan in a moment.
Yeah, so, you talk in paragraph 18 here about when it was in Crown ownership and there was no protection put it on then. Surely that would have been the time to do this as opposed to after considerable investment has been done. Because people obviously rely on planning laws for certainty and investment decisions. If we have planning laws like we're suggesting here, where there is no certainty, we risk people not investing in older buildings. So how do we make our rules consistent so that people don't face retrospective problems, or whatever big term?
I think the problem is that was 40 years ago. And we've had multiple, either when they were just district plans, and then we've had the operative, the Wairarapa combined district plan since. I can't speak as to the decisions made for by the council officers or the councils at the time, but
I suppose
it's
try and think of it.
yeah.
My house that I built
Mhm.
is 25 years old. In another 50 years, what's to stop someone's going, oh, now that's a heritage building?
Well, I guess that's the thing with heritage, is that it's an ever evolving space. We're living history right now. So possibly in another 20, 50, 70 years time, those future planners,
But people
I think
need to understand what the effect is going to be if they do something before they start, not after.
Let me ask you a planning question. You've in your 42A, you reached a recommendation that the listing should be retained. In your summary statement, you've said, having had the benefit of reading Mr. Hooper's evidence and Mrs. Smock's statement, you want to reflect on that position, but you've acknowledged that it's a fine balance between the cost to landowners on one hand and the potential loss of heritage on the other. How have you and how will you seek to resolve that tension? Got a Section 6 matter on one hand, and you've got a property rights, property values issue on the other.
Yeah.
What's the guidance in the Act or in planning policy to help you? Is there anything in the objectives and policies or in the Act that would help you resolve that tension? Because you talked about the policies and objectives being of assistance during a resource consent, but they also have a role in the plan making too, don't they?
Yes. Yeah. That's where I refer to David as well in his assessment of these buildings. But in terms of, yeah,
and then some questions about the heritage value. Let's assume let's ask those questions now. Mr. Kernahan, you presumably have assessed the heritage values of the site prior to the site being included in the notified proposed district plan.
Yes, and unfortunately, this is probably going to be repeated this afternoon.
Yes.
When the Smocks are here. My first involvement was with Griff Page in 2002.
Yes.
When it was first discussed about Wairarapa doing a heritage inventory.
Yes.
In 2005, I produced a draft which included the Greytown Hospital.
Yes. This is all pre-2010 and the first.
It was all pre-2010, and I had, as far as I can see, the district plan became operative on 25th May 2011, and the building was not included on it. I had no discussions with Griff in the intervening 4 years. So as far as I was aware, my recommendation had obviously been rejected.
Yes.
And
in the preceding plan, or the combined plan, was there any listing at all?
no,
No.
I only, as part of my reporting, I had the building recommended for listing.
Okay, so you undertook an assessment in 2005, you recommended it was included, and when the combined plan was notified in 2010, it wasn't included, and the operative plan didn't include it either.
I also included it in this book in 2005.
2005. And that book is the
Wairarapa buildings. If you're not got, you should have a copy of it.
Yeah. Jumping here 11 years.
Yep.
When were you first engaged in terms of work on the proposed district plan?
It would be around 2019.
Okay. And what was your involvement in this site?
The involvement was to review the lists of all three councils.
Yes.
And to make suggestions about additions.
Yes. And presumably deletions.
And deletions, sorry, yes, absolutely.
Yes.
And that I was to consult with local interest groups and the councils and council officers, which I did. So I met with people like Carterton Historical Society,
Yes.
Greytown Heritage, had discussions with Martinborough Museum, quite a range of people, and inviting them, if they wished, to make submissions about changes to the list, either, as you say, deletions or additions.
You say people, is it those organisations that you've just mentioned or individual landowners?
No, just with the interest groups.
Was there any discussion with individual landowners? Was that part of your remit?
it was not part of my remit, and I think I make it clear that part of the remit was that owners had no preferential rights, and there was another condition which come to me.
No, that's fine. When did you?
Sorry, the other one was the condition of the building
Yes,
is not relevant.
Okay.
And that comes from the Act.
yes. When did you first start reviewing this site after 20?
I'm familiar with the site from around 2000.
What was the nature of your investigation on that site?
I was just aware of it and walked around it and thought it was a handsome looking building.
Did you visit the site?
Yes.
Did you go onto the site?
I went round it. I don't know whether, I can't remember what was fenced and what wasn't, but I had a good look.
And were the renovations complete at that stage?
No, this was
Before.
talking 2000. I'm talking when it was had been abandoned by the Crown and was under.
Sorry, I'm talking about post 2019.
I'm sorry, I thought you were to.
No, post 2019.
2019. No, I've just seen it from the outside, but there were, there's also, there was information on the internet as well.
I'm just going to ask you that. What other sources of information did you
The
consult?
internet.
And was the renovation, what stage were the renovations at the time that you saw it post 2019?
Oh, it was,
Late?
I mean, what's been done is excellent.
Yeah, but that's not my question. What stage were the renovations at the time that you viewed it?
I can't remember.
Have you seen the building in its completed renovated stage?
Only on the internet.
Only on the internet. Okay. How would you characterise its heritage value in its current state?
Well, the site goes back to it was the first hospital building in the Wairarapa, goes back to 1875.
Sorry, that's not quite correct, is it? Because the original hospital is currently in cobblestones now.
But it was on that site.
Yeah, but you said it was the first hospital building. It's not the first hospital building. You said it was the first hospital. Yeah, you did. Yeah, you did say building. Yeah.
Sorry, my mistake. It was
First hospital site, is that what you're saying?
hospital site. The first cottage hospital was built on that site in 1875 and was removed in, I believe, 1974 to cobblestones, which raises a whole different series of arguments.
It does, doesn't it?
We'll not go there, perhaps. And the brick building was built in 1905, and the Art Deco, so called, because it's not Art Deco, couldn't be Art Deco, was built in 1913. There were 10,000 babies born in the ballroom. The ballroom is still intact as far as I understand, although materially it's different, but the space is still there. So 10,000 babies from Greytown. It's a pretty horrific vision, actually, all at once.
So the site has some heritage significance.
Yes, Russian Czech died there. Local figures, many local figures were in and out of that hospital.
What?
The brick building beyond the cottage hospital. And I understand that about several thousand people went down to Parliament in the late 1990s to protest about it being closed, not about its architecture or its heritage, but the fact that it was being closed as a facility.
How would you categorise the architectural significance of the buildings that are there today?
It's an interesting institutional building. It reminds me of the Seddon Technical Building up in it's brick, a brick exterior, which for most public buildings in the Wairarapa is quite unusual. It has a particular, I think it's quite an attractive building. But it was going through demolition by neglect. Clearly the council wanted it off their hands, and they thought that that not putting it on a heritage list would help that, which is an interesting irony. And of course, it then became a non-notified resource consent,
Yep, understand all that.
which is concomitant to a decision not to list it. And someone, council or council officers, and the
You just focus on your area of expertise, not the politics.
that's my area of expertise.
Have the renovations changed the architectural significance of the building in any way such that they no longer have any heritage?
On the contrary, I think I am dismayed by this SMOC's attitude towards heritage listing, because heritage listing ought to be a bonus rather than a.
Yeah, but just keep to the facts, please. Yeah. Don't want any commentary. So I'll just repeat the question. Is you said on to the contrary, the architectural significance hasn't been
It's been enhanced.
enhanced?
Enhanced.
Okay. Okay. That was a segue, but before I finish, yeah.
I've got a generic question, not specific to this topic, but it is a question for.
Can you mind parking? We'll come back.
Got another one on.
Yeah.
Yeah, so are you aware that it is actually originally two buildings that have now been merged into one?
Yes.
Okay, so is the significance of each building architecturally significant, or is it now because of what the renovations have done?
This goes back to our earlier discussion about place and site. And I don't know what there's now 7 subdivisions. I don't know whether they are part of should be on the heritage inventory or not. The place is what is in my description, and it features the SMOC's house as being a significant architectural feature.
So could you just clarify that for me? Are you saying the site is historically significant,
Yes.
or the building, or both?
Both.
Okay. And then I come back to my original question. Then there are 2 buildings on that site which have now been merged under the renovations by the Snooks into one building.
Yes.
What does that do in terms of the architectural design and historical design? Because it's used to be 2 buildings, now one.
Yes.
So, and that's been done in the
Well,
very recently.
in terms of heritage conservation, it's good practice. This is good practice. It's rather like the Greytown Town Hall, which is vastly different from its original. But I did a heritage assessment for Mr. Page in 2027 to show that it was good conservation practice what was done to Greytown Town Hall. So conservation accepts growth and change, and accepts change of use, but it tries to record what the essential heritage is. The essential heritage is in my mind, that the Greytown Hospital was there from 1875 to 1990, whatever, and these buildings are part of the record of that heritage.
Would you consider that the Snooks actually agree with you in that, and that's why they have saved this building?
Absolutely.
But we're now penalising them by doing that.
I know.
So what is the risk of not putting this on the register, given the investment and the saving that the family has done to this stage? Are we? And I come back to my original, the original question to say, are we penalising people by saving a heritage building, which would discourage us doing it in the future?
It's a very good question, and I mean, I can be very smug and say, well, if they'd taken my advice and 2012 or whatever and put it on the list, would Mr. Van Barl or the Smocks actually have walked away? I don't know. It's a moot.
Well, they've stated it.
Council.
It's stated in their evidence they would have.
Yeah.
So, yeah.
Yeah, but that's perhaps in hindsight. Mr. Van Barl says he was negotiating with South Wairarapa Council for 10 years before. So he was involved with discussions with the council as demolition by neglect became more and more and more, which was and I'm not being political at all, but it's a bit of a bargaining chip.
Could I just ask one further question? What would you determine the risk of not including this on the list, given the investment that's gone into this place,
Very low. The building's safe,
regardless of whether it's heritage or not?
regardless of whether it's heritage or not. I mean, I know the Smocks are trying to sell now, and I'm sure the new owners will, whoever they are, will come in and will treasure what's been achieved by the Smocks. So I'm not particularly worried about it. I mean, it's ironic because there's been decisions made that aren't somewhat opaque.
So just to make sure that I've got this correct, you would have no objection to it not being included, given the investment that has done exactly what you would hope to be done to that building.
Yes.
Cool. Thank you.
Thank you. Any further questions of Mr. Kerner?
He just asked it.
Just the generic one.
Yes.
So, Mr. Kernan, I see that you were contracted by Boffa Miska to do the overall assessment of these buildings, all
Yes.
these buildings. Just my question, did you physically inspect any of them, or was it just a desktop review?
I visited them all. And I made sure that they were there,
All right. Thank you very much.
Anything further from my way?
except I must say for the joinery factory, which was a total conundrum. Sorry.
Thank you. Kerner. So Becca, we're back to you, and I won't put you on the spot, but you've heard about the heritage significance of the site and the buildings. And we'll hear this afternoon from the Smocks about the issue of fairness and property values, property rights. So want you to think about what guidance we can get from the Act and the plan to resolve that tension. Okay, we'll move on to the issue 2.
Yeah.
Now, I just wonder, in the interest of timing, given what you say in 23, right through to 28.
Yeah.
And it seems that when Mr. Raymond are on the same page, on both Jellicoe Street and the railway tunnel and the water drop shaft. And tell me if I've got that wrong.
No, that's correct. I can jump to paragraph 29.
Okay, thank you.
So Mr. Raymond for Heritage New Zealand maintains their position to map the heritage curtilage of each item listed in Schedule 1. Mr. Raymond states that defining a clear boundary removes uncertainty and ambiguity around application of plan for the provisions for rules relying on the concept of heritage curtilage. I note two rules and one policy refer directly to heritage curtilage, these being R2, R5 and P6. R2 is a permitted activity and unnecessary to assess in this instance. R5 manages new or relocated buildings or structures with the curtilage of a heritage building or item listed in Schedule 1 as a restricted discretionary activity. Matters of discretion restricted to those matters listed in P6 and the relevant matters in either the residential or centres design guides. P6 provides for new buildings or additions and alterations within a heritage curtilage where compatible and where viability and values of the heritage building and item are met. In considering Mr. Raymond's request, I note that Wellington City Council and Thames Coromandel District Council have assessed and mapped the curtilage of each scheduled heritage building and item. The curtilage has been mapped where the curtilage is identified beyond that of the entire external building envelope. I've got examples there. I appreciate the mapping of heritage curtilage extents may provide greater clarity for plan users, particularly those buildings and items within residential and rural areas. However, with over 400 listings in Schedule 1, the scale and cost of undertaking this task is considerable for Wairarapa councils. The benefit of this work would be for the interpretation and application of one rule and associated policy, and I consider the cost outweighs the benefit of undertaking this mapping work. An alternative I considered was amending the rule framework to reflect that of the proposed Far North District Plan. The proposed Far North District Plan permits any new buildings or structures, extensions or alterations where they are set back a minimum of 20 metres from a scheduled heritage building or item. Where this setback is not met, the activity becomes a restricted discretionary activity. This alternative may be too restrictive, capture other properties, particularly within the urban areas, and may not adequately capture rural heritage curtilage. I also considered removing the rule and policy. However, both the immediate and wider surrounds form an integral part of retaining and interpreting a building and item's heritage value and must be appropriately protected. I maintain that the current rule framework for a restricted discretionary activity, with matters restricted to those listed in P6 and the design guides, adequately capture the heritage values that the Wairarapa councils and Section 6 of the RMA seek to protect, without being unnecessarily stringent and costly for landowners. Landowners would need to arrange a pre-application meeting with council officers to determine whether the rule is triggered. I recognise that this is a time cost to councils and landowners and requires council officers to use their judgment or alternatively the applicant to determine where the curtilage applies. I note that the additional cost comes only to those landowners who wish to develop within the heritage curtilage. However, where proposed buildings are located outside of this area, this is a permitted activity subject to zone and other overlay rules and standards. I recommend this request be rejected and heritage curtilage not mapped.
Okay, we'll have some questions from Mr. Raymond this afternoon. What I can say is from a panel's perspective, situation that you've outlined in paragraph 38 is not appropriate and not acceptable.
Okay.
So we are going to have to look at some remedy here. I can also say that I think at this stage, without hearing from Mr. Raymond, the idea of mapping the curtilage for the 400 listings is probably not going to occur, Mr. Raymond. So we need to look at an option somewhere in between, and that might be looking at the definition of curtilage as a stopgap measure. That's not to say, Mr. Raymond, that mapping could occur subsequent to this as a separate process, but that would involve a procedural process down the line. But I think in terms of fit for purpose solution, I think see what you've got to say this afternoon. But at this stage, I'm thinking of suggesting some further conferencing between yourself and the council on that matter. Okay, issue 3, non-contributing buildings in the heritage precincts.
Mr. Raymond and Ms. Cooper maintain Heritage New Zealand's position to retain Schedule 2, so long as contributing and non-contributing buildings are identified within each heritage precinct, as well as include descriptions of the characteristics and values of each precinct following a heritage assessment. They consider that this work and amendments will better apply rule framework and avoid adverse effects on heritage. Ms. Cooper recognised that while this task can take time, the benefits of doing so include a simplification of the resource consent process and removal of regulatory burden for owners of non-contributing sites. Firstly, I agree there is merit in amending Schedule 2 to include a description of the characteristics and values of each precinct. Appendix 4 has such descriptions on Masters Crescent, Victoria Street, and the residential areas of Greytown's Main Street. However, detailed descriptions are absent on these precincts within the commercial, general rural, and open space zones. Although an information-only amendment, it will add value to understanding of Wairarapa's heritage precincts and will address this request from Heritage New Zealand. I've been unable to prepare this description ahead of this hearing. However, I can produce these amendments through my reply statement. Finally, I acknowledge that identifying contributing and non-contributing buildings within Wairarapa's heritage precinct would benefit some landowners in avoiding the cost of obtaining a resource consent. However, the character and value of the heritage precincts are interpreted by the features and buildings of the area as a whole, and it's important that the council have an opportunity to assess each activity on its merits and the consequential effects of the activity on the site and wider precinct. For example, should a landowner within a heritage precinct wish to demolish a building, this currently requires resource consent as a discretionary activity under Rule 10. In the following key issue below, Heritage New Zealand seeks this be a permitted activity where the building is identified as non-contributing. As a permitted activity, this approach does not allow council to assess the effects creating a vacant site, which may have adverse effects on the character and values of the heritage precinct. The current approach enables an assessment of the demolition of the existing building and the design of the new building at the same time, which would be more effective in maintaining the character and values of the heritage precinct. Additionally, much like the previous key issue, there would be a reasonable cost of undertaking and mapping this work. I consider the risks of potential loss of character and values of the heritage precincts and the financial cost on councils outweighs the benefits to landowners avoiding consent costs. I therefore recommend this request be rejected.
Again, we'll hear from Mr. Raymond on this. In your paragraph 44, are you recommending that that information amendment be undertaken?
Yes. Yeah.
Are you confident that it is only an information amendment? Will it have any impact on the way the rules are interpreted, the assessment that might be undertaken?
I don't believe so. I feel like the policies capture.
What would be useful, regardless of what we discussed with Mr. Raymond today, is in your right reply, if you could give us a table for each of the precincts that includes the following information, whether it's a new, existing or extended precinct from the ODP, number of properties in the precinct, and whether the precinct contains scheduled buildings, and if so, which ones?
Okay.
Be useful.
Yep.
What I'm getting from you, Becca, is that you see some value in going down the contributing, non-contributing track, but to do that at this stage won't be a simple exercise, is it?
Yeah, that's correct.
That it would have been useful for that to have been undertaken from the get-go.
Possibly, yeah, and I was still involved in that those early stages. But yeah, I do see the merit. Yeah. But yeah, I do see the merit in it.
Yeah.
Um,
So in the absence of that approach, basically everything is a discretionary activity, isn't it? Just the removal or the addition of buildings are looking at H10, R10 and R11. So R11 is an RDA, but R10 is a DA. Is there any reason why both R10 and R11 couldn't both be RDAs?
no, that was something I did look at, and I think I landed on the matters of discretion might be quite extensive, but I can look at that again in my reply statement if you think.
I'll put that to Mr. Raymond also, because again, as a stopgap measure, that might be something that could be investigated further. Okay. Sorry, and I'm just Chairman, I think we could go to key issue 4 then. Paragraph 49.
So Mr. Raymond for Heritage New Zealand requests that clause of P3, demolition of non-scheduled buildings within a heritage precinct, be deleted given the new policy PX. I agree with this request as PX provides for demolition of non-scheduled buildings or items within a heritage precinct and better aligns with the outcome sought by council. And I've amended that in Appendix 3 of.
Sort of rearranging the deck chairs there on a policy sense.
Yeah. And PX, Mr. Raymond proposes a minor amendment to PX with the replacement of non-scheduled to non-contributing in both the heading and the body of the policy. And I guess that's given my recommendation to not identify a map. I recommend no wording changes.
And R2 and R10.
So Mr. Raymond states that the proposed district plan does not differentiate contributing and non-contributing buildings within the demolition of removal of buildings or structures in a heritage precinct. It's a discretionary activity under R10. Mr. Raymond considers that the additional policy, PX, does not address Heritage New Zealand's submission to amend R2 to extend to the provision of demolition for non-contributing buildings within a heritage precinct. Mr. Raymond therefore recommends that the addition of non-contributing buildings within a heritage precinct to R2. Mr. Raymond notes that if an amendment to R2 is accepted, then it is necessary to amend R10 to differentiate contributing and non-contributing buildings within heritage precincts. Mr. Raymond recommends R10 be amended so that the demolition or removal of contributing buildings or structures within a heritage precinct are a discretionary activity. I acknowledge that PX does not address the provision for the demolition of what Heritage New Zealand refer to as non-contributing buildings that they sought. As per my assessment in the Section 42A report, I'm of the opinion that a discretionary activity status is for such an activity is appropriate. My reason for introducing PX was due to an unintended gap in the policy framework, whereby the wording of P3 as notified enabled the demolition of non-scheduled buildings within a heritage precinct. This is an obvious issue due to the number of precincts being Solway Showgrounds, QE2 Park, Victoria Street and Masters Crescent as being comprised of non-scheduled buildings. The wording of P3 as notified offered a potential pathway for resource consent to be approved via policy to allow demolition and ultimately lead to the potential loss of all heritage character and value in these precincts. My position remains that a discretionary activity status is appropriate for the activity of a demolition of any building within a heritage precinct. Heritage precincts are identified for their overall character and values, and it's important to control such activities like demolition within these areas on a case-by-case basis. Furthermore, as I recommend non-contributing buildings and contributing buildings not be identified and mapped, I recommend no further amendments to heritage rules. I guess
obviously we're just asking you to revisit your paragraph 56. Okay, I think unless there's anything in the 58 that you want to draw our attention to, or 59, then just finished with reading paragraph 60.
I don't think there's anything there. Yeah, based on the matters raised in submissions and pre-circulated expert evidence, the following key matters remain in contention to be considered during this hearing: whether to retain former Greytown Hospital in Schedule 1, whether to identify and map heritage curtilage of scheduled buildings and items in Schedule 1, whether to identify contributing and non-contributing buildings and items in Schedule 2, and whether to make consequential amendments to rules to reflect contributing or non-contributing buildings.
Thank you, Adams. That's really useful. Any final questions, Adams? Yep.
I'm struggling to find, when we started these rules, we sent out letters to all affected homeowners, yeah? So I haven't seen a spreadsheet that said who we wrote to and what the result of that. was. So I'd like to see that, please. And I'd like to see for those people who, and whether they replied, no reply, yes or no. For the people who said no, I'd like a little bit more assessment on what would be the effect if we granted their application of no. What's on the high side? Thank you.
Anything? Thank you, Ms Adams. Gorman, we're going to go straight to you and then we'll have our lunch adjournment. Oh. That's me. The answer. Don't need one of those, I've got one already.
Favourite subject?
Having said that, well, welcome, Mr. Gorman. It's nice to have you along here. I don't think this is going to take too much time. Your summary is pretty brief. You might as well start at paragraph 5, if that's okay with you.
Okay, paragraph 5. There were 3 original submissions and of 3 submission points and no further submissions received on the definition chapter in relation to notable trees. Total of 10 submissions with 53 submission points and 3 further submissions and 7 further submission points were received on the notable tree chapter. There were 7 original submissions, being 13 submission points and 7 further submissions received on the schedule of notable trees. The submissions on the notable tree definitions relate to the definition of qualified arborist, how the root protection area is determined, and the narrowing of the definition of street trees. The submissions on notable trees relate to the standardisation of the stem threshold across all 3 councils, and whether there should be different thresholds for native exotic trees. Second was amending permitted minor tree works for adequate mitigation. Requiring landowners that object to a proposed notable tree listing on their site to provide reasoning for their objection. Terminology changes. Support for the objectives, policies and rules, with some amendments requested in some of the submissions. Request for some rules to be deleted. That was in relation to street trees, giving notable trees a similar status to heritage sites, and that the notable tree chapter did not properly consider to Treaty o Waitangi. The submissions on the notable tree schedule relate to whether specific trees or groups of trees should be added or removed from the schedule. In terms of pre-circulated evidence, I've read the respective evidence of Tom Anderson on behalf, allowed to abbreviate to the telco companies. and Ainsley McLeod on behalf of Transpower. Respond to this evidence below. I acknowledge the general, sorry, something in my eye. I acknowledge the general support of the recommendations from both parties who have pre-circulated their responses. The primary concern related in the pre-circulated evidence of Tom Anderson is the proposed substitution of trim and trimming with prune and pruning, and has requested that the original wording trim and trimming be retained. Take this off. Yeah. The change was recommended in response to submission from Jeremy Partridge, noting that pruning was the more correct arboricultural term. Richie Hill, the arborist assisting councils, agreed that that was the correct term from a arboricultural. Mr. Anderson has noted that many recent district plans, the Telecommunications Act, the electricity hazard from tree regulations use the term trim and trimming, have viewed the Act and regulations and agree that these are the terms used. Mr. Anderson has set out the dictionary definitions of trim and prune. While there are differences in the two terms, I do not think that differences are significant enough that council staff would resource consents for tree work intended to be permitted in the district plan as provided in the above mentioned legislation and also the government guidance. Although I don't think there is a need to revert back to the use of trim and trimming, rules that reference the relevant legislation to both terms. I have provided a revision to the recommended changes in Appendix 1 to include both terms. May be appropriate to include trim and trimming.
Thank you, Chris. Just ask you to break there, see if there's any questions.
Okay.
Robin.
I was going to say good morning, it's good afternoon now. On the inserting pruning or trimming, I just noticed going through the chapter changes that we haven't included or trimming in a number of areas through the policies and the rules, and just want to know, was that just an oversight or is there a reason? Is it inconsistent throughout? It's probably just a copy and paste, but I just wanted to clarify.
It was more where the would coincide with the legislation that uses the term trimming, that we could essentially say for the same thing in these particular situations.
Do you think for clarity for plan users, if it doesn't create any adverse situations, that it would actually be more consistent to just have pruning or trimming the whole way through instead of pruning in some instances, pruning or trimming in others?
I think I'd like to take advice from our arborist in terms of whether yes, there is a significant distinction between the terms that they do need to.
Yeah, I understand that. I'm kind of looking specifically at Rule 1 and Rule 3, whereas in the headline or the heading of it, you just say pruning, yet under the activity status for rules, we've got pruning or trimming in some instances.
Yeah.
so therefore, I guess my question would be, why is the heading not consistent with what is contained
The same applies, Mr. Corbett,
in
with some of the policy.
Well,
too.
yes, yeah,
You know, in policy 2, you've deleted the word trimming and then added in pruning or trimming.
yeah,
Policy 3, you've deleted the word trimming but replaced it only with pruning. For both activities that are appropriate or potentially appropriate, can't understand.
Okay, so,
For that.
so yes, so policy 2 includes work that the I can call them infrastructure. These might be carrying out work under the district plan.
Well, not solely, that's only C.
Yeah,
A and B would involve works other than infrastructure works. Yet both of them, all three have the benefit of pruning or trimming. Whereas policy 3 only has the benefit of pruning. And you said earlier that you looked at the dictionary definitions that Mr. Anderson provided, and you don't think the difference is significant enough for the staff to request resource consent based on the difference in terms. So we're just wondering why both terms aren't used consistently throughout policy.
well, I guess I would have no objection whether we went throughout to say pruning or trimming.
Yes.
Yes, I would like to.
If you want to reflect on that and you're right to apply, that would be good. I'm not so sure that it's an agricultural type issue, it's more of a planning issue.
yeah,
But
absolutely.
you reflect on that anyway. Yep.
Makes it simple.
Anything else? No? Okay, and we'll just move on now to. Sorry.
Yeah, Chris, thank you. And I know the document, the rules and the policies talk a lot about underground infrastructure. And just looking at P7D, and of course, the thing that comes to mind about the natural shape and form of the trees is the Martinborough issue where we've cut the hole out of the trees where the power lines go through. I'm not sure what street it's on. That's literally it's cut the middle, you know the trees I'm talking about, eh? So I presume that will protect those trees in the future, but in the rules, we don't talk about anything about what happens when power lines are encroaching on the trees. So, because obviously we don't want to see that example occur again. I don't know if you've ever seen these trees, cut the middle out of them. They're probably historic trees now on the heritage listing because they're unique in New Zealand.
Have a look at rule 3, A.
No danger.
Yeah, but that one doesn't sort of link back to the policy about keeping shape. So somehow we need to, keeping the shape may be in direct conflict with power lines.
The pruning shall not be helpful. 3.
Yes, so do not impact the natural shape of the tree stream. And then,
yeah.
I'm just quite sure.
Okay. Don't have the submission to deal with it either.
Yeah.
Well, and that's going to be my question. What happens when we come up with, when the power companies and the utility companies come up with the utilities chapter? Is this going to link? Is this going to be consistent with our utilities chapter?
I guess we are all reliant on their qualified arborist undertaking the work solely for keeping trees out of the lines, but maintaining the appearance of the trees.
So I just want to make sure that under the utilities chapter that we're not going to be having submission on utilities chapter, which then affects the trees, which they haven't made a submission on the trees because they're doing it in the utilities chapter.
Yep. I noticed
not in isolation.
Notice Mr. Hill's online. Welcome, Mr. Hill. Is there anything you've heard that you want to comment on, Mr. Hill?
No, I mean, the only thing, dealing with some of my other hat, because I'm the president of the NZ Arbor Association. We've been making submissions about the change in regulations to pruning around trees. So it's good to have something that you guys can be objective in there. Does that make sense? Because if you've got the power line companies who say like we want no risk, want everything to go, if we don't have some form of controls in there, and I don't know what the right wording would be, but like you were saying, it's good if it can link to everything, to safeguard those trees. So you don't, because some of the situation we have even in Auckland, like it's some areas where they've just decimated trees to try and get these clearance because it comes from the utility companies, and it's some of the changes in the regulations, they're targeting maybe shelter belt landowners, but it's having unintentional consequences for amenity trees as well. So I think what we've tried to do is let it up to the local authorities to actually make their own definition so you can get it within what's reasonable. Does that make sense?
I think so. I think the panel's reasonably comfortable with the structure of the chapter.
Yeah.
It's really just some of the terminology that's used and the wording that we've asked Mr. Gorman to revisit, and just for consistency.
Yeah, and I agree. I think trimming is just something that was more archaic. It was something that was used, whereas pruning is the more sort of modern terminology we'd use. And trimming would indicate to me a hedge trim. It's tried to emphasise that it's minor, but you can just add that we're using the word minor trimming.
And it does do that, but the issue is that where minor trimming and pruning is used in one rule and not on the other, that creates an inconsistency. So we're just asking Mr. Gorman to revisit that in his right of reply.
Yeah, I think either works fine, and I think whatever's going to be easier for you guys to get that consistency is.
Thank you for your input, Mr. Hill. And good luck with the work around the country.
Thank you.
I think Mr. Gorman was, unless there was anything else that you wanted to draw our attention to. And we've got the one matter of contention. We've made some other changes that don't rely on the pre-circulated evidence.
No.
Yeah. Thank you for your time.
The Lansdowne nursery site.
Oh, right. Yes, apologies. Yes, so if
Have we missed something?
So in the Article 3 schedule, there was a submission to include trees from what was the Lansdowne nursery. At the time of court, council hadn't secured permission from the landowner to gain access. That was subsequently obtained. Mr. Hill, I think, found that even though permission was gained, it was securely locked up. But he has been able to make an initial assessment of the trees, and there are 3 trees that would appear to threshold of 120 stem points.
Okay.
So I think at this point in time, it's now up to council staff to then go back to the owner to say that those 3 trees were identified for.
Who was the submitter, Mr. Gorman, that requested the addition of trees from the nursery, the former nursery?
So it was a neighbour.
So there's scope for the inclusion of the 3 trees. Is that is that your recommendation?
Well, I think if we have the agreement of the neighbour, of the landowner, then yes, we should include trees.
And when will we know that?
I'll need to talk to my Masterton colleagues.
Okay. Right reply. Yeah. Okay. So is this This issue canvassed in the 42A. Okay. Are we hearing? Are we hearing? We're not hearing. Or are we? No.
I wish to be here.
Who's the landowner?
Can you remember the new trust that's bought it? Christine's been doing the liaison.
Trust. Okay. Is that not a submitter?
No.
No further submission?
They provided permission to access the property that are aware. They've not been unpaid.
Well, if you could report back on that, then that would be my most useful. Okay, 12:15. Unless there's any pressing questions, you know, we'll adjourn now till 1 o'clock, is it?
I'm 15.
1:15. Hearing's adjourned 1:15. Thank you, Goodies.